Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good morning. I hope everyone's doing great this morning. I'm doing pretty darn good. All right, so this is just a review of, and it was because some people were concerned and wanting to know how the SSA can seem to make these decisions when it doesn't seem like Congress gave them a particular power to do so. In the context that it was asked about, the person said, well, I don't see that Congress said that you have to have an MRI to prove that you have a serious back condition or what have you. And it's like, right, Congress doesn't get into the detail weeds like that. And it's true that you do not have to have an MRI to prove an impairment if you have something else that is persuasive enough. So, but here's the rub between congressional statutes and federal regulations, which are not created by Congress. All right. So here's what this particular document put up by the Congressional Research Service. And I think it's a really good one. It's only 3 pages, guys. I'm going to link it so you can go back to it if you're curious. You know, this isn't something you have to act on. It's just that if you're wondering, how can they do that? Here's why. So Congress often, and I'm going to do a bit of reading back and forth and jumping back and forth. What is federal rulemaking? Congress often grants rulemaking authority, right in a statute, generally, to federal agencies to implement statutory programs. So if there's a statute about Social Security, the SSA is going to have the authority from Congress to draft up regulations to make their statute effectuated, basically, because your congressperson isn't running the SSA. They just created it, gave the rules, and then other people have to implement them. And to do that, they have to make regulations as to how that's going to act, how that's going to take place in real time with real people in the practical world, in the offices we have, and what, etc. So the regulations issued pursuant to the authority carry the force and effect of law. That's huge. And it can have substantial implications for policy implementation. Right. So how the policies of, let's say the statute where Congress, envisioned XYZ, the federal regulators in the agency to which it pertains have this tremendous power to kind of affect how it's implemented, right? How it's going to take place, which can affect individuals intensely, right? So the agencies are required to follow a certain set of procedures prescribed in law and executive order. These procedures collectively comprise the federal rulemaking process. And they give us a quote from a case called National Latino Media Coalition versus the FCC. That's the Federal Communications Commission. So in this case, the case is not the SSA, but it's another federal agency, right? It says a valid legislative rule is binding upon all persons and on the courts to the same extent as congressional statute. So that's a lot of power these regulators have. When Congress delegates rulemaking authority to an agency and the agency adopts legislative rules, the agency stands in the place of Congress and makes laws. It's really immense. So why does Congress delegate rulemaking authority? I kind of alluded to my little summary of why I think they do, because they can't actually implement them themselves. They're busy running around campaigning and sometimes passing laws for the better and sometimes passing laws for the worse, right? But the Congressional Research Service tells us that Congress delegates rulemaking authority to agencies for a number of reasons. Perhaps the most importantly, agencies have a significant amount of expertise and can fill in technical details of programs that Congress created in statute. This can be useful for Congress, which is responsible for establishing policy in a wide range of issue areas and does not necessarily have the same depth of expertise that agencies may have. And that kind of makes sense, right? We don't expect our Congress people to actually be experts in all things of life, right? In addition, even after delegating rulemaking authority to agencies, Congress retains its legislative power, which gives it the ability to conduct oversight, modify or repeal regulations, and amend agencies' underlying statutory authority. So Congress doesn't really give up its own authority. It just delegates it over here. They can do what they are going to do, and then Congress has the power to smack them down. And one thing that whole statement reminded me of is when we have a problem with an SSA case, not on the merits, not on the adjudicator's decision or what have you, but say our case is sitting at the DDS for 9 months without any movement, like there's no one even working on it. We might reach out to a congressperson and say, hey, can you see if this case has fallen through the cracks? So they can do more of an administrative light a match to get things moving versus they don't interrupt the substantive decision making, because that would be a bit of corruption. I think we would all agree, right? They can't be the god of who wins. That's not their role. But like I said, because they have oversight over the agency, that's why we go to our congressperson when we have an issue with the agency and some sort of procedural mishap where our case has fallen through the cracks, someone hasn't gotten their back benefits, we haven't gotten our fee, things of that nature. Just when there's a cog in the wheel, not a issue of substance where discretion and fact finding has to take place. Okay. As such, they go on to say, delegating authority to agencies can enable Congress to focus on the big picture issues rather than spending its time and resources debating all the technical details required to fully implement a complex public policy. Congress instituted a number of procedural controls on agencies, such as ensuring that the public would have an opportunity for participation through the public comment process, which SSA has. I see it not every day, but quite frequently. And that's required by the Administrative Procedure Act, another law set by Congress. There are also a number of reasons they go on to tell us why Congress may not want to delegate rulemaking authority, however, or reasons for which Congress may want to do so with caution. So they have discretion, Congress, over if they're going to and how much they're going to delegate that authority. One commonly cited reason is that unlike members of Congress, agency personnel and officials who write regulations are not directly accountable to the electorate. And this is what we see all the time, right? They can, well, let me go on. In addition, Congress faces the possibility that the agencies will issue rules in a manner that Congress views as inconsistent, where are we going up to, with congressional intent. Generally speaking, the more precise statutory directives are, the less discretion an agency has to independently develop policy objectives. And you guys might remember that very recently, the Supreme Court overruled a case called Chevron that came about in 1984. And it was a pretty overwhelming overturn. It was 6-3. And they overturned that. That case gave the agency regulators the power to, when it was kind of like, if the statute doesn't say specifically and we think it's vague, we can interpret it the way we want to. And that, the case is called Chevron versus Natural Resources Defense Council. It's old, but it has been precedent, and it was overturned, I suspect, largely because agencies were running a bit rogue, making interpretations or regulations that are really far-fetched from the original intent of the statutes or the policy scheme by Congress. So I think it was good to be overdone. The unelected bureaucrats in the agencies were literally having the power of making laws when they weren't elected, and they're not accountable because they don't have to worry about getting reelected, do they? All right. And I can't agree more that the more precise statutory directives are, the less discretion an agency has to independently develop policy objectives. And this is because they are corralled in by the limits of the statute. So, and I think of this often because even in contract drafting, which most of us lawyers have had to do here or there, even if we're not, our field is not drafting contracts, which would bore the living daylights out of me. But oftentimes we do have to engage in contracts, negotiations, or reviewing a contract to make sure we want to use it, execute it. I happen to be one that does put more detail in. Some lawyers like to have it really vague. And the thing with vague contracts, and this would be true of what they're talking about here, is then people say, it didn't say that, so therefore. No, if you put all the rules down, put all the rules down. The ones that have to be rules, you put them down. Because otherwise people say it's not in there, therefore. And that's how everyone ends up in court. Litigation, litigation, litigation. And the same is true with regulations and the SSA. We saw this a lot in divorce law. There are some lawyers that like to do quick and easy, charge $1 million, do a quick and easy settlement agreement that will then be ordered by the court if both parties agree to it, oftentimes. And I see some really, back in the day when I used to do this, it's been over 20 years, some real sloppy that you could just read it and go like, oh, that's going to be something that's going to bring us right back here. And the funny little non-funny quip about that is that some of them keep them vague because you make more money as a divorce lawyer on post-divorce motions for the next 20 years between two people who were divorced 20 years ago because of that vagary that was put in that settlement agreement and then had the power of the order of the judge. So being sloppy and vague, some people say, I don't like to read a lot. Well, and I know people who say that all the time. Don't do it. Don't do so much, explanation. Wrong, wrong, wrong. The more vague you leave it, the more you are likely to be back in court because the other side is going to take advantage when it suits their interest. Okay, so that applies to with congressional statutes that are more open-ended and then everyone can just run with it the way they want, whatever the regulator wants. Not good. They go on also to give us an overview of the rulemaking process. First, they say, there's a little chart here too, it's kind of cute. If the statute authorizes the rulemaking, the agency then develops draft proposed rule. I see this all the time. It comes through us from the SSA. The OIRA then reviews the draft proposed rule. The agency then publishes the proposed rule. The agency receives comments and makes changes to the proposed rule from us, the public. It can be us who work in the field, but we're still the public. And it could be, people that don't work in the field, but have an interest in the whole idea of what this proposed rule will do. OIRA then reviews the draft of the final rule. And then the agency publishes the final rule. And then it goes to judicial review, congressional review, whatever the case may be. So that's how those things happen. Now, the changing of the Chevron precedent really reins in the power of these agencies to make the rules up as they go along, so long as there is not an express prohibition of doing that by Congress in the statute that is current. Can it make some things slower? Yes, I think that's possible. I really think Congress needs to, and when I say slower, I mean good things that want to be changed. Yes, they can, but guess what they should be doing? They should be going to Congress and getting them to amend that law instead of doing it themselves, because doing good is as possible as doing bad and vice versa. And we saw a lot of the bad, which I think is why the Supreme Court this year decided that's not working. Giving them those unelected bureaucrats in the agencies unfettered ability to make regulations that hold the power of law when they are not legislators and they're not elected by the people. Not good. My opinion. Anyway, so I was glad to see it happen. This is a great little summary, guys. If anyone wants to look at it a little closely, I only kind of reviewed the basics, but it's 3 pages, which is not overbearing. This came out March 19th of 2021. So it's not, yesterday, but it's not old either. Have fun with it. if that's up your alley. I'll talk to you later. Bye.